Hello, how you all doing? So let's go straight to it. We're going to talk about patent law, and if we have time, we'll talk about the law of confidence as well. I don't know if we've done that already, but let's go to patent law. So what is a patent? Okay, patent is like a license. Okay, a license that gives an inventor the right to an invention. Okay, giving them the sole right to an invention, okay, that stops others from using, selling, or claiming that that thing belongs to them. That's what a patent is. Okay, so patents are granted for new, non-obvious, say new, something that's brand new, something that's not existed before, non-obvious um, inventions that have industrial application. And industrial application means practical use, and that it can be applied in the industries such as agricultural industry, technology industry, any industry you can think of. Okay, so the good thing about this patent law is that it makes inventors, like it gives them some confidence that, I mean, they can create something and it will be protected from others. If you understand what I'm saying, gives them this monopoly that they own this thing. I own this thing and nobody can make alterations to it, nobody can claim it as theirs. So that's what the patent law does. Okay, so there are two types of inventions that are patentable, that patents are granted for, and that's the product and process inventions. Product and process, as their name implies, a product is an item. Okay, it could be a hardware, it could be a software, and it could also be integrated circuits. Integrated circuits are found in all our electronic devices. So that can also be a patentable invention. And then a process, you know, from what it implies, a process is a way of doing something. It could be the way you make Milo is made, the formula you use in making Milo. And I gave an example when we tried to do the online class. It could be the quadratic equation. You remember that almighty formula? That's the process of solving the quadratic equation. That is a patentable invention. It actually belongs to someone, and you cannot wake up in the morning and say, oh, I invented the quadratic formula, the quadratic equation rather. So those are examples of products that can be patentable, and then process that can be patentable. And obtaining a patent is a very lengthy process. It's complex as well. So oftentimes they advise that you get a patent agent who does the running around for you, the stressful aspect, just like when you get an agent, like a house agent, when you're looking for accommodation, you get somebody who goes to look for the houses for you and comes back to you to give you information. Or like when you're applying for visas, some people do get agents for visas, like when you want to apply for visas. I don't know about that, but I've heard. So it's desirable to get a patent agent who will do the running around, because filing of a patent involves filing the claims, and also, you know, drafting the specifications of that patent. Someone who knows about these things in details has to do it, not you. So that's why they normally advise you get a patent agent to do that aspect. So we say that this applying for a patent is actually a lengthy process. It takes up to 5 years for your patent to be approved. And so why does it take this long? There are so many reasons why this process takes long. One is because they do a lot of stringent searches and examinations. That's the patent people. They do a lot of searches and examinations to ensure that your patent, your invention meets the patent requirements. So that's why, one of the reasons why it takes long. Okay. Another reason why it takes long is because even after they do that first stage of examinations, they will get back to you, and then they will still do some more, again some more evaluation, and so many things are involved, so it takes long. So they are here, we have the steps for applying for a patent. The first one says you do the application. The application is done first, describing the invention, and it also includes an abstract. Okay, the abstract has the title of the invention and a summary, and then the claims. Then the second step is the patent office now will carry out a search for patent and other documents which may be relevant to your invention. Then the third one is after 18 months following the first filing for the application of a patent, there's something that you get. The patent, something will be published, and that's called, that particular one is referred to a publication. So after 18 months, you have something called the A publication. Then the next phase, the patent office examiners will still carry more extensive examination of the patent application to confirm if it meets up with the requirements. Okay, so after that, you have the last phase, which is where the patent is granted and published, and that is called the B publication. So you see why this takes long. It's a very lengthy process. Some people are lucky, theirs might come out early, while some will take a long time. It's just like when you even apply for a visa. Some people can get theirs out in like a week, some people 2 weeks, 3 weeks. Everybody's case is different, so the same applies to when you are applying for a patent. Then there's something called the priority dates. Priority date simply refers to where the first time, the first date in which you filed for a patent application. That's called the priority date. So even if it was a provisional application, provisional submission, whenever they are treating it, they start counting from that day which you filed, that date. So that date is called the priority date. So even if you go to a different patent office, like maybe you filed for a patent, let's say for instance in Lagos, okay, the day you filed for it, if it was today, what's today, 13th of November 2022, and then after a while, maybe they're still delaying you and all whatnot, you're impatient, you now go to Abuja to file, and then you filed, let's say March 5th, 2023, they will still treat that applications with that date of November 13th that you filed. That's the priority date, anyhow you want to do it. So that's what priority date means. Now, there are some basic requirements for a patent to be granted, and the first one is the invention must be new. It must be a new thing. It must not be something that already exists. That's the first one. The second one, it involves an inventive step. The third one, it's capable of industrial application. Just basically, it can be useful. It has practical use. Excuse me. So now, what is an invention? You guys already know in layman terms. What is an invention? Okay, invention is something that they say is making something new from an old thing, or making an old thing using a new method. Okay, making old from something new, making a new thing using an old method, or making an old thing using a new method. So invention is just something you create. It creates, but it has to be different, has some things that are different from what has already been in existence. That's in layman's terms. Okay, and then I said industrial application suggests that an invention is something that can be put into practical use. That's what industrial application means. It should not just be an idea, and you don't patent an idea, you patent something that can be used into use. A patent should not be granted for anything which is not new. Okay, it must be granted for something that is new, and if it's something that is already in the public domain, that's the public already know of its existence, a patent cannot be granted for that. Like says here that, for example, that if a company has been making integrated circuits with a particular kind of process, and then but they never filed for a patent, then another company is now uses that same process and now wants to file a patent for that process. The process will not be given a patent for if that process was in the public domain, if people knew about the process, even though company A never filed. But if it's a process that nobody knew about, it was just something that, because sometimes we have the same ideas. If you notice, you can be in your house and have an idea, and then when you go and check on Google, somebody has already come up with that idea. So it's possible that company B also came up with that same idea on their own, not knowing that company A uses that same process. So if company A never put that process out in the public domain for people to know about, then the patent will be granted for company B's process, even though it's the same company A, but nobody knew that company A was using such a process. So, what does obvious mean? We said a patent is granted for a new non-obvious invention. Obvious means it has, has no special meaning, but means that when you look at the invention, when you look at it, okay, you can see that it's strange. It's not, the same with something else that already exists. That's putting it in layman's terms. So it says here that computer technology spreads into all kinds of other technologies. You know this, right now computer science is applied in every domain you can think of. Okay, so and then when you combine computer technology into these other domains, you get inventions that are patentable. Like now, you apply computer to agri-science, agricultural sector, you apply computer science to the banking sector. Like now in the banking sector, all the apps we use are all made by computer scientists, programmers, software engineers. All these are our apps for transferring money, even all these PiggyVest, all those things. So those things are patentable inventions, especially since they are new. Even though you have things similar, but like when they make all these things, they apply it to a specific domain, like PiggyVest. Now in America, such things exist like Cash App and all, but PiggyVest is for Nigerians to apply to our own needs here in Nigeria. Cash App is not for us. So that, like, PiggyVest is a patentable invention. I hope I'm making myself clear. So we've talked about industrial application. They said a patent must have an industrial application. If not, an invention must have an industrial application before a patent can be granted for it. They said that the need for industrial application shows that the practical nature of a patent shows the practical nature of patent law, which requires that invention should be something which can be produced or that relates to some sort of industrial process. So you cannot grant patent for something that is useless, that cannot be used for industrial purposes. So let's move on. We'll talk about this aspect. It's called entitlement, especially in the workplace. You'll be wondering, like, if I'm a worker, for instance, in a company, and I develop something, I make an invention, what am I entitled to? Okay, I'm sure you have read it, but it says that the basic rule is that the inventor is entitled to the grant of a patent. Okay, and then the owner of a patent is known as the proprietor. It's proprietor. Okay. So, but in the case where the inventor is an employee in a company, for instance, okay, it says that if that invention was made while the employee was working under his normal duties, the time he was supposed to work, for instance, if he was to work 8 to 5, Monday to Fridays, and he made an invention within that time, office hours time frame, that invention belongs to his employer. That's what it says there. You have to read it very well. Okay, that invention belongs to his employer. However, he might be compensated for it by being given a bonus or increase in salary or something. But as long as he created that thing while working during his working hours, it belongs to the employer. Okay. So it says in terms of employee investors, the following points are important. Either the invention must result from the employee's normal duties or specially assigned duties, or the invention must be one which could reasonably be expected to result from the employer's performance of such duties, or the employee must have particular responsibilities arising from his normal duties, imposing a special obligation to further his employer's undertaking, or the invention was made in the course of those duties. So that's what I was saying. So but if maybe he created that thing when he was at home on Saturdays and Sundays, or when he was on leave, obviously he didn't do it in company time, so he's the owner of that invention. So as I said, the owner of an invention is called its proprietor. So you should know this. So infringement. So when is a patent infringed? Infringement means, having access to something when you're not supposed to. Like when they say infringed on something. So a patent is infringed, okay, when or if a person does some certain things in relation to the invention which he's not supposed to, or which the owner of the item, the invention, did not give him permission to do. So you infringe on the owner's rights, and that attracts jail time in a working society. Like taking someone's thing, like you say, like for instance, a software, you say you are the one that made it, you start selling it, like piracy, all those things where you take Nigerian movies, for instance, where they go and pirate it and sell, or all those foreign CDs we used to buy in those days. You go to the filling station, you see them selling Aliyah CD. Meanwhile, the originals, we can't afford them. Maybe the original will be like 15K, but they will come and be selling 500 nights. Those are piracy, and that's, that attracts jail time in a normal working society. So that's about what we are learning for patent law. Every other thing you can read up. If you don't have, if you have any questions, there's something you don't understand, you can always reach me. Or you can let your course rep know, and then I can, I'll give out my email. So you have questions, you email me. Or, you can ask questions on that, because I'm going to upload this on YouTube. So you ask questions on that video, and I will answer you as immediately I see it. Okay, so that's for patent law. So basically, all you need to know is what is a patent, why is patent law important for an invention. It's really straightforward. You're not supposed to know everything in details, because we're not in law school. But this is information technology law, so we need to know at least the basics concerning it. So the next video will be on the law of confidence. So I can tell you a bit about that as well. So see you in the next video. Thank you for listening. Bye.